done a few cases on plea bargaining. And I'll discuss those, and perhaps we can understand from that why plea bargaining is not so popular. So even in this case under the Arms Act, the client and I, we did explore the option of going for a plea bargain. But the difficulty with plea bargaining is that a lot of discretion is left with the judge. And this is
there are three kinds of offenses. One is moral turpitude and
those
social
are
economic,
economic, of course.
7 years or more punishment.
Indeed. So those, of course, are out of the question anyways.
This one couldn't get into any of those categories.
No, this was not under any of those categories, but still we did not approach the court for that. The reason why is that the provisions under plea bargaining under the CRPC also state that after recording a plea of guilt, the court can pass any order including up to half the sentence which is prescribed under the code, under whatever code it is. So the difficulty is Arms Act, 5 years I plead guilty. The judge has complete discretion to pass any order up to 2.5 years of imprisonment. And what makes the...
This is the plea bargaining
Yes, this is plea bargaining. But the bigger challenge with plea bargaining is that, okay, for example, for a moment, let's say that, all right, 2.5 years I get also. So then I feel that, all right, it's a bad deal. And I want to approach the courts in appeal for that. But the difficulty is that precisely because plea bargaining, no appeal is allowed. That is why it becomes a problem. And this is exactly what happened with one person when he filed a plea bargaining and he was actually convicted and sentenced to, I believe, 3 months of imprisonment for an offense under the Customs Act. So we were representing the department where, to be honest, I don't even remember what actually happened at the very end. Because we were, we dealt with the case for several years, and then I think I moved out of the senior's office. But while the time we were dealing with it, that was the same question that came up. The judge recorded a plea of guilt, and the difficulty that the accused person faced was he was under the impression I'll be because very, very rich party, violation of the Customs Act, importing either gold or some misdeclaration.
This is an economic offense.
I
don't know. There must have been some exclusion. So.
Yeah. I mean, you can call it, yeah. So I guess that is one aspect which was perhaps not considered by the court. Perhaps that would be this thing. But any case, so conviction and 3 months of imprisonment versus, of course, 3 years could have been there. But if the counsel or the client would have known, especially affluent people do not want to spend a day in jail. So if they would have known that something like this could have happened, they would have definitely gone for trial. And now they are stuck with filing a writ petition in the High Court, challenging the order, and on very, very limited grounds. So every time the matter would come up for a hearing before the High Court judge, at that particular point of time, what I remember is the first question that the judge would ask is, how am I supposed to interfere with this? Do you have any precedent to interfere with this? And at least at that point of time, whatever research I had done, I could not find any precedent to say that once a plea like this has been done and judgment has been passed, what is the remedy? That is the reason why plea bargaining has not been so effective. And to be honest, I have never really kind of understood the system as it happens in the US, because to my mind, it is a flawed system where, at least when it comes to guilt, you are either innocent or you are guilty. If you are guilty, the state should come up with enough evidence to prove beyond reasonable doubt that you are guilty and you should be convicted. And if you are not guilty, or perhaps the state does not have enough evidence, you go scot-free. The difficulty with plea bargaining, in my mind, and that too just looking at Hollywood movies, I have no idea about how these things work in the US actually. But the problem that I can see, even if we were to say perhaps introduce this kind of a system in India where we do away with the system against filing of an appeal, the problem is that a lot of times someone who is innocent, who is falsely implicated, and these things happen in India, is then given an option, okay, then it again becomes another problem that a person who has not committed an offense is now goaded into saying that, all right, you confess or you plead guilty, and then you go ahead and you suffer the sentence, or perhaps slap on the wrists. But at the end of the day, the police will get away with what they want to do, is to falsely implicate someone else, or maybe a complainant who has falsely accused a person. A lot of times what I see in nowadays, especially because I've been doing a lot of cases regarding offenses against women, especially a lot of matrimonial matters where I represent husbands, and sexual harassment cases where a woman, the wife of maybe, like, so if two people are get into a fight, neighbors get into a fight, the wife of one neighbor will file a case of sexual harassment or outraging the modesty of a woman against the other neighbor. This has become a very, very commonplace practice. And a lot of these situations, the clients come to me, men come to me and say, bhai, I did nothing wrong. And then I am suffering this completely outrageous charge. What am I supposed to do? And the only answer I have for them is, ki bhai, just stick it out. At the end of the day, you have enough evidence in your favor. Most men invariably do, that you will be able to secure an acquittal for yourself. But if I can imagine a situation where plea bargaining becomes the norm and these few problems are dealt away with, a lot of people who are falsely accused will also concede to it, which I believe is a greater travesty of justice than certain kind of matters getting dragged on.